এই আপনি কি করবেন? আমাদের মেন ফিক্স ছিল শুক্রবার দিন গিয়ে পাঠান। Yes. Friday, my lord, the matter was fixed under the assigned part heard, my lord. That first appeal, my lord, will Mr. Ghosh has completed, will take half an hour, my lord. On Friday, it was fixed, my lord, any day. Just said.
That will matter.
Will. Only 1 hour. Will happen. তোমরা আধ ঘন্টা আছে পুজো রিপ্লাই আধ ঘন্টা Liberty was granted to mention the matter. The appeal.
A fresh matter.
Yes.
Contempt, fresh matter. It was not heard.
No.
It was our order.
No.
Then
it was appeal under section 19.
Against whose order?
It is the order of Justice Chandra.
19 what?
There was some defect there.
They removed the defects. Yes.
Yes. Milord, this is the appeal of 2021, Milord. This was admitted, Milord, on 9th August 2021. Now, Milord, I retired on, Milord, 31st December 2018. Milord, after retirement, Milord, there was a direction passed by the DI that the HRA, Milord, that I had withdrawn, Milord, I was not entitled to, Milord, the amount, Milord, which I had withdrawn. As a result whereof, Milord, a direction was passed by the DI, Milord, directing the Treasury, Milord, to recover 5.5 lakhs amount, Milord, from my retirement dues. Now, Milord, I have
mentioning about notice, Mr. Basu.
Yes, notice. Now, Milord, if your lordships kindly direct this matter to be posted on any day, Milord, as to be mentioned, because when the appeal was admitted by the Honorable Division Bench presided over by Justice Audit Sinha's lordship, then was, Milord, there is no direction for filing paper. So it is required, subject to kind convenience of this Honorable Court, Milord, to direct this matter, Milord, to be posted on any day, Milord, under heading to be mentioned.
No, there is is there any application filed in connection with the appeal?
It appears no, Milord. But the paper book, Milord, automatically. Milord,
show us what was the order passed.
Milord, this is the order, Milord. I'm sorry, Milord. I tender my apology. It says, Milord, the Honorable Division Bench, Mr. Bosch, an advocate, appears on behalf of the appellant. He submits there should be interference with the impugned order dated January 3, 2020, to the extent that his client's retrial benefit, less a deduction on account of house rent allowance, be paid to him pending hearing of the appeal. He further prays the deducted amount must be deposited by the concerned respondent in an interest-bearing account in favor of the appellant. Mr. Mukherjee, learned advocate, appearing additional government pleader, appears on behalf of the state and submits state cannot be directed to deposit any money on account of wrongly availed of HRA. As there appears to be no dispute regarding rest of the retrial dues to which the applicant is entitled, we direct that such dues upon deduction of aggregate HRA drawn, aggregate rupees 5,57,904, as informed by the memo dated 4th December, be paid to the applicant. This disbursal be made within 4 weeks from date. Applicant has liberty to mention for hearing of the appeal when it is made ready.
It has not been made ready. It was 2018 order.
2021, 9th August.
So you have not filed paper?
No, because made ready, Milord, there was no application, Milord. Informal paper book may be directed to be filed. If it is placed, Milord, under to be mentioned, Milord, I will.
You have got the remaining amount. You have got the remaining amount.
I am receiving, Milord, provisional pension and the other amount after deducting 5,57,000. Now the rest of the amount, Milord, disputed amount, I require this, Milord. Otherwise, Milord,
the application has not been disposed of.
Only, Milord, kindly the paper that I have used, Milord, before the trial court, I may be directed to file, Milord, informal paper.
Let us see. Let it application. Application disposed of. Your application has not been disposed of. Your
can 2 and can 1, Milord, it appears from the order dated 9th August, Milord. Yes, can 1 and can 1 and can 2 both are disposed of on that date, but there is a
So make a one-line application. We will keep it as application and direct filing of paper books. ওটা ওনাকে দিয়ে দাও, make a application, give a copy to other side and mention so that we can give that direction. Yes.
One new application for inclusion in the
Yes.
list.
Your Lordship, it is a long pending matter filed in the year 2023. Both side oral arguments have been submitted before Honorable Justice Harish Tandon and before Honorable.
After the vacation, madam, it is a hearing matter.
New
Yes.
matter, my lord,
Yes.
for inclusion, my lord.
Application.
No, my lord,
Hearing matters mention after vacation. Yes.
My lord, this is an appeal, my lord, for inclusion in the list.
Sir, remind us after the vacation. Yes. Call the list.
Need to mention a matter. Lordship, this matter is
What you are mentioning?
MAT appeal, your lordship, for inclusion in the list.
Final appeal, final hearing or application?
Your lordship, in the appellant have said
Take
that
the mic, sir. Take the mic.
The appellants have had taken directions for making certain amendments in the appeal, your lordship, but the direction is passed in February and thereafter they have not yet carried out any kind of amendments and they are enjoying an injunction, your lordship.
So take appropriate
Lordship,
steps.
we have filed appropriate application for substitution, Lordship, and the last order was passed in May 25. The deed of assignment was not registered before.
No, what is this? An application pending or
Yes,
the
Your
appeal hearing?
Appeal hearing, your lordship.
That we have filed an application for carrying out amendment.
Substitution.
Yes, Your
So
Lordship.
that application has to be allowed first.
Yes, Your Lordship.
Lordship,
And
they have
over that
filed, they have sought leave for making amendments in the cost title as because the asset has been given to some asset reconstruction company. Now this direction was passed back in.
this is an education matter.
No, my
Your
Lordship, this is a
What you
group
are mentioning
Group
before?
9 residuary, Lordship. The determination has changed subsequently in the month of July, Your Lordship.
We are not having residuary determination.
No, Lordship. This is the determination has changed.
Matter was
Check up the record, sir, and file. We don't have that determination to consider. Yes.
May be permitted to mention matter in relating to an habeas corpus matter. Your lordship was hearing this matter on the basis of submission made by the learned
What
counsel.
are you wanting?
My lord, let this matter appear because there was a direction from the apex court, because on the earlier occasion your lordship was kind enough to direct this matter to appear after a period of time because of pendency of a particular
Your
proceeding.
Lordship, I am appearing for Union of India in this matter. Your Lordship has fixed this matter on 10th.
The matter was mentioned
This is pertaining to Bangladeshi citizens who were deported.
and the apex court have clarified and said that these particular applications are not connected with the application which has been filed before the honorable
What
court.
do you want,
My
sir?
lord, let this matter it appear, my lord.
It will appear.
My
You
lord.
must have
On 10th, Your Lordship. You have fixed it on 10th.
fixed it on 10th. We are not giving adjournment. We
Your
share.
Lordship, we will do it.
For lordship.
restoration application.
Yes. So, Mr. You also give a notice to
My lord, I have given notice and also I will give a further notice that
give
matter.
further notice there.
Grateful.
আচ্ছা, শুনুন। What is the order pass?
My lord, may I just hand over?
You ring up Miss Pandey
My lord, I will.
and ask her to join
My lord,
us.
may I go out and just give him?
Let her appear for.
আইটেম অন হয়েছে
September 10th.
Go through it. Supreme Court direct.
Well, plain who has been detained and subsequently, my lord, deported to Bangladesh. Sonali is not the petitioner. For Sonali's cause, this
Abhishek,
petition was filed by
Now the
Abhishek.
Sonali is pregnant.
Yes, my lord, that we have done that she is pregnant.
Where is she? You told
My
her?
lord, probably she is before another court because I have tried to ring him up and he's just disconnecting it. Probably he's some other.
Meet her
My
and
lord,
come and mention at 2 p.m.
Grateful,
Also
Lord.
inform the state advocate who is appearing that we have granted you leave to mention it at 2 p.m.
Grateful, Lord.
and ask her to be present.
Grateful.
Yes, Mr. Bhattacharya, you showed us page 134. Your argument was that you are aggrieved by this direction to appear before the school. Is that your
Yes,
submission?
yes, but because on twofold ground. First is the Honorable Chief Justice The last order that I have annexed,
That you did not show to the single judge.
I placed it.
You placed it.
Yes, yes. My writ petition was of 2024 and the order was passed in 2025. I placed the order before the Honorable Division Bench, Honorable Single Bench, 137.
Yes.
It is absolutely, the single bench's order is absolutely contrary to the order of the Chief Justice.
Why do you say so?
But kindly see what the Honorable Chief Justice has said, 140.
Yes.
Therefore, without casting any aspersion on the ex-headmaster Anupam Nando, the auditor who has been appointed shall conduct an audit, and the president of the managing committee as well as the present teacher in charge shall extend cooperation for the audit. And after the audit report is prepared, it should be placed before the managing committee, and after discussion, the minutes should be recorded. And along with the said audit report, and the minutes of the meeting of the managing committee, the same to be placed before the district inspector of school, Paschim Medinipur, who shall thereafter proceed to take action in accordance with law. Then, upon receipt of the document, the district inspector of schools, if need be, can seek for assistance of the ex-headmaster, that is me. If needed, then he will ask me, I will assist him.
So what did the single judge say?
Kindly see. Paragraph 10, 134. The president of the managing committee of the first school, the present teacher in charge of the first school, and the petitioner shall cooperate the audit to get the account of the first school audited within the stipulated time. Then,
So what is the wrong in this?
then.
So there is nothing wrong in paragraph 10.
Only to why I have come to this court.
No. Paragraph 10, what is the wrong?
The wrong is,
Cooperate.
I will cooperate with the I will cooperate with the district inspector if I am called. That is the order of the Chief Justice.
Paragraph 10 as it runs,
Yes.
there is a recording that the petitioner along with others will cooperate.
Cooperate the auditor to get the account of the first school audited.
So
within the time stipulated.
there is no but to that effect in the Chief Justice's order.
No.
Now, then which paragraph are you aggrieved?
I am aggrieved. Kindly turns to first takes up page paragraph 10. Then the district inspector of schools, paragraph 12.
Paragraph 11 is in the...
In the event the petitioner does not cooperate with the auditor, the same shall be disclosed in the report of the...
that he will disclose.
Not required. I have said on the last occasion, I have given a copy to your lordship that I have gone to the DI and said that yes, I am ready to cooperate in 2023. I left the school 3.5 years back.
Which portion is contrary to Chief Justice's order? Tell us that.
Paragraph 10, first thing. Second is...
Paragraph 10 is cooperate. There is no...
cooperating kindly turns to the Honorable Chief Justice's order once more for my satisfaction. 140. Therefore, without casting so and so.
So you mean to say you will not cooperate?
No. I will not go to the school.
Where is the direction in the single judge's order?
Cooperation, the premise of the main writ petition was that I will cooperate with the order impugned of the commissioner has said that I will
Cooperate with the auditor.
I will cooperate with the auditor. Then the president was directed of the earlier school was directed to take action, to take resolution against me. And if something is found wrong, kindly takes up the impugned order once.
Page 60 is the impugned order.
Just a second. Page 60.
So there also it has been said you will cooperate.
Your lordship allows me. After getting the audit report, the president of the managing committee of so-and-so school, the earlier school.
No, this is after. At the time of on considering on keeping in mind allegation
and counter allegation against each other,
engaged for such and such. The president of the and Anupam Nando are requested to extend cooperation to the auditor.
Engaged by the director of school education.
So upon this cooperation issue, Chief Justice had not said anything.
No.
Chief Justice said that you will cooperate. Chief Justice said,
I will cooperate, but at the office of the DI. Only this much. I will go to the DI office. I will go to the DI office, but not to the school, earlier school, which I left 3.5 years back.
So where is the direction to appear in school? in the order impugned, where is that direction that you have to go to the school and cooperate?
But kindly sees 134.
On Zodia. Why dictionary will appear different?
Yes, 12. While the petitioner will appear before the auditor for extending necessary assistance for to complete the audit, he shall not be obstructed by any of the parties to the writ petition. But where I will go? If I go to the district inspector of schools, I have no objection. I have said 1,000 times that I will go to the DI of schools because that is the order of the Chief Justice. But let kindly clarify that. Only to that extent I have come to this court, come to the appellate court. Only to that extent that I will go to the DI. I will not go to my earlier school.
Now, where is that you have been asked to appear before the auditor?
Yes,
Now, where
the
from
audit will be conducted inside the school. What they have said on the last day and before the first court, that the audit will be done inside the school.
Then the paragraph 11 becomes meaningless. Paragraph 11 says that if you do not cooperate with the auditor,
Well, that is not the purport of the Honorable Chief Justice's order. Kindly cease. Kindly cease the Honorable Chief Justice's order. Just a second.
you see the order which has been impugned by you.
Yes.
That order says cooperate with the auditor.
I will.
So where is the when you will cooperate with the auditor, you have to appear before the auditor.
Well, I tell your lordship, this order of the commissioner, which I have questioned, this order was passed in 2024, 2023, when the Honorable Chief Justice's order was not there. This order has come in 2025. Kindly see the two dates of the commissioner's order and the Chief Justice's order.
So after the commissioner's order, there has been no development, no audit has been.
No. But I have challenged the order of the commissioner before the single bench. The Honorable Chief Justice says, as the petitioner has challenged the order of the commissioner before the single bench, we are not we are not making any comment on it. Let the single bench will take up the matter and do justice to the petitioner. That is the purport of the Honorable Chief Justice's judgment. Then they filed a contempt against the commissioner. In the contempt, my lord, I filed an application for addition of party and modification. In that modification, kindly have a look to, my lord, the order. Page 137 starts from. Which part has been modified? 138. Paragraph 4. The applicant in Can 1 and Can 2 is also aggrieved by the further direction issued by this court, dated 14 January 2025 in CPN so-and-so on the following. Notice was served on the alleged contemner number 1. And
that
he
does not contain any direction as regards appearance before auditor. That is, disciplinary action will be taken. That was struck out.
Not only that, next part. The Anupam Nando, now working as so school, has not rendered any necessary cooperation for completion of the audit from financial year 2019-2020, so though they have been they have issued letters 3 times seeking his cooperation, but not the auditor. The school has written to me. Why I will reply to the school's letter? I will reply to the auditor's letter. This is number 1. Number 2, since the highest authority, namely the Commissioner of School Education, has made such observation, we direct the Commissioner of School Education to take necessary disciplinary action against the Anupam Nando so-and-so. These 2 paragraphs were modified. Paragraph 8, 140. Now your lordship kindly sees paragraph 8. Thereafter, without casting any aspersion on the headmaster, the auditor who has been appointed shall conduct the audit, is very important. And the president of the managing committee as well as the present teacher in charge shall extend cooperation, not me. shall extend cooperation for the audit, and after the audit report is prepared, it should be placed before the managing committee, and after discussion, the minutes shall be recorded, and along with the said audit report and the minutes of the meeting of the managing committee, the same to be placed before the DI. Well, where is my role? Then, upon receipt of the document, the DI, if needed, we can seek the assistance of the ex-headmaster. Here is my role. So, the order of the single bench, kindly clarify that. Because the order of the single bench says, paragraph 12, while the petitioner will appear before the auditor for extending necessary assistance to complete the audit, he shall not be obstructed by any of the parties to the writ petition. Where from this issue is coming? If I don't go to the school.
Which letter you showed us that you
Well, I have given it to your lordship. Well, a single page letter. And
that is-
another interesting part, this one.
Acha, we have got.
Yes. 9th of October 2023. I have written it to the DI.
That was prior to the order,
No, that was,
23 order.
yes, because the commissioner has passed the order in 23, page 60. 8th of May 23. I wrote this letter on 9th of October 23. I have shown my bona fide. You, with honor to your member so and so, I am to inform you that all documents, paper, and assure him necessary cooperation for smooth conduct of the audit. I have said that I will cooperate. After that, the order of the Chief Justice has come.
Mr. Bhattacharya, this cooperation, you say that you will extend all cooperation to the DI after filing of.
That is the ballot order of the Chief Justice.
Yes, what?
Well, it kindly turns to page 139, the order in contempt. Para 7.
Yes.
Since the order dated 18th May 2023 has been challenged by the ex-headmaster, that is Sri Anupam Nanda, to that extent, the order need not be complied with and will be subject to outcome of the writ petition filed by the appellant in WPA 48. This is the present writ petition from which the appeal arose, present appeal arose. So, my lord, thereafter, however, these orders will not be barred for the audit to proceed further in the matter for which the president of the managing committee and the present teacher in charge should extend full cooperation. So, my lord, this order, my lord, says, my lord.
So, Mr. Rai, we will clarify only to this effect that this order, the court division bench order proceeds on the basis that the audit has to be completed. For that, all necessary documents and cooperation of the school authorities is required. In the order impugned also, there was a further direction that he will also have to cooperate. So the single judge said to the auditor that if he does not cooperate, in that will be recorded in his report and it will be submitted to the DI.
Yes.
And DI, he will be at liberty to call for the petitioner an explanation. This thing of personal appearance before the school was not a requirement in the division bench.
My lord, without handing over of charge by the ex-headmaster to the present school authority, the school authority is not in a position to produce the record before the auditor.
Tell that to the auditor.
My lord, kindly then record my submission that he has not handed over any of the charges to the school authority. He has handed over the charges before the district inspector of school, certain documents with the undertaking that he will again hand over the charge on such and such date, but he has not handed over nothing. He has
So
not.
why didn't you tell that to the appeal?
My lord, I have, my lord, in appeal court, I am not the party respondent.
You are the school. You are the school. Because
Yes.
Maiti.
No, Bikash Maiti was the villager.
So, Mr. Rai, where is your statement?
My lord, in that
No,
PIL,
we will clarify only, we will record your submission. But if the order of his lordship would have been passed taking into consideration the appeal court order, then those two becomes incompatible. Division bench says that president and secretary will cooperate with the auditor. Auditor will prepare the report and give it to the DI, and DI, if felt necessary, will call upon this writ petitioner. He is ready and willing to appear before the DI. We will
After
also
completion of audit, my lord.
after completion of audit. Now in the audit, when it will be, auditor must ask, will have to ask you
Yes,
that Mr. Roy, where is that record which you are wanting auditing of the accounts?
yes.
There lies the problem. So that is why we are not modifying that part of the order which says that auditor will record that.
Yes, my lord.
Auditor will record that this is an instance of non-cooperation, since charge was not handed over to them and they are not in custody of the documents. So he has handed over charge not to the school. All consequential steps will follow in the writ petition.
Yes, my lord. And my lord, another thing, my lord, if my lord in contempt court, Honorable Division Bench presided over by Honorable Chief Justice has modified the order of my lord, the Commissioner of School Education. So, my lord, where is the requirement of this entertainability of writ petition? The writ petition became infractuous because their challenge is not, they have challenged the writ petition.
You are right, but the division bench itself says that the writ petition is pending.
Then, my lord, the order of the Division Bench is self-contradictory.
Who said?
Because of the fact,
It is
one way Division Bench has said that you have to comply with this order. In this order is subject to final outcome of the writ petition.
Right.
And another way, my lord, the Division Bench modified the order. So, my lord, where is the scope?
So that is modified the order. Yes, we are only saying that because the division bench order which has modified the earlier order do not contain any statement to this effect that he has to be personally present before the auditor for auditing. That is not the direction. We will only clarify to that. The present appeal has been
No,
paid. Oh, Mr. Chattopadhyay, yes, sorry.
Paragraph 12, Malo, why paragraph 12 of Justice
This-
Bench order?
Pardon?
First, paragraph 12.
Admission.
Learned advocate of the petitioner, Mr. Bhatte, in his own volition, he has submitted. They will appear, but give some protection. Paragraph 12, for this reason, the paragraph 12 has come.
And it
He
is
has
not.
not produced the division bench judgment at the trial court.
No, that he
Paragraph
says
12.
he has produced.
No, who said?
But
It is not.
While the petitioner will appear before the auditor for extending cooperation for assistance to complete the audit, he shall, where is my statement recorded? It is the direction of the
No,
court.
Mr. Chattopadhyay says that this paragraph would not have been mentioned in the order because you on your
No,
volition.
Yes, my lord, yes.
Then,
For this
Are
reason,
Baba,
This is
then why I have come in appeal?
for this
That is
reason,
exactly he is surprised.
Then,
That
for
why
this-
you are coming up in appeal. It is on your instance the court said that well.
Yes.
no.
my lord, he
But I have
mentioned
repeatedly
some
said,
protection.
I have repeated. Where is the finding of the court that it is the submission of myself?
That is in the live stream.
Arey,
My lord, it is already recorded in the YouTube live streaming. If we,
হ্যাঁ, তুই দেখে নে।
I'm not,
Why
my
the
lord.
question of necessary assistance will come. He has asked for, give me some protection.
I will ask for
What-
and I will
what
come
is-
up in appeal against the order.
For this reason, my lord, the
And
paragraph
We
12 has
will remove this obstruction. We will remove this rider of giving him any assistance. Remove
Yes,
it.
remove it. Kindly remove it.
My lord, another
Order.
thing, my lord, I want to submit. My lord, in writ court, the challenge submission of the petitioner that he has challenged the writ petition only on the ground of one observation is there, my lord, in the order of the Commissioner of School Education, the managing committee will decide for forwarding the issue before the disciplinary authority. It is his challenge before the writ court. Now, my lord, after passing of the order by the learned single judge, he has, my lord, voluntarily, my lord, submitted that I will cooperate.
So
I
that,
will render.
Mr. Rai, how we can accept whether he has done it voluntarily.
Sir, he is a habitual offender. The next full malad, same allegation has been
একটু
made.
দেখি না, রোজ তো
Mr.
বলে যাচ্ছেন এক কথা।
Chattopadhyay, we are not disturbing. Here it is said in the paragraph 12 he is agreed. Next paragraph says DI being the shall supervise the entire and felicitate the auditor to complete the process and submit a report. So that in tune with paragraph 9 of the Chief Justice's order, district inspector for doing that can always seek the assistance of the petitioner. He has to appear before
I
the
will.
DI. And we will record that he will be present as and when called for before the district inspector of schools.
I will.
But may I be permitted to mention, because I am the person who initiated the public interest litigation.
based on which there is a direction upon the commissioner. Commissioner passed
He
this
has
order.
not made a party. His application has not been allowed by the single bench.
That
That is
doesn't mean
pending.
that I can't say anything.
No, you cannot say because you are.
I can.
But for the villagers,
I am for the villagers.
you
Now,
are party to this writ
my lord,
petition
Application
we
is
file an application for addition of party in the single
that
bench
is pending.
that is pending. Now, my lord, I have been served with copy of this appeal by my learned senior friend itself. I am not here a stranger. He served a copy upon me.
Maybe have sir, but
Based
you
on
have,
which
you
I am
have not
before
been
lordship.
added as a party.
My
Mr.
single
Jahan.
submission before lordship would be the order of Chief Justice during pendency of the writ petition.
Yes.
During pendency of the writ petition,
Hmm.
any order which would be passed in the writ petition that will prevail. Because the writ petition has not been
No, subject,
subject to.
not prevail.
Now subject to. Now the subject outcome is this present order. The
Which-
present direction, which is under challenge with your lordship.
No, present direction, this is a challenge against the director's order,
Yes,
which says cooperate,
yes.
complete, take disciplinary action.
That is the order. Subject to this outcome of this writ petition means this writ petition.
Yes, this
Yes.
writ petition.
Now this is the first time
So
something
where
is
is
coming.
the direction that you appear before the school? His only content is that I will not appear to the school, I will be before the DI. We will
Yes.
record that.
Now,
Hello, what right
The
the villagers
Wait,
have?
wait, you have completed.
the commissioner said he has to be.
If the DI says he has to be, we will record that. He will
But-
personally
but-
appear as and when record before the DI.
A problem is there. Don't take me otherwise. The entire process would be hampered.
Why?
The audit process, the audit that would be stopped. In absence of documents and other things, it would be stopped.
Are who is claiming that?
Like why you are saying?
Well, he is a villager.
Why wait? Now, why do you say audit will be stopped? If that is expressed by the auditor, that will be before the single judge. That
Let
audit
that-
has been stopped
let
due
that
to
be.
his
Let that be.
non-cooperation.
My lord, then, my lord, may I, subject to acceptance by your lordship. My lord, the present school authority will, my lord, hand over all the documents
Not
which
hand
they
over,
have
produce.
produced, all the documents before the district inspector of school. My lord, let the audit be completed in the office of the district inspector of school.
Now,
Because,
that-
my lord, each and every occasion he has,
No,
it is the submission of the,
if the audit is done in the school, and let's say the auditor says 1, 2, 3, 4 documents are missing, he will intimate the district inspector who will ask for the documents from him.
yes, my lord,
Will
kindly,
resolve
kindly,
the
kindly,
we will remove
Kind.
your apprehensions.
kindly.
The
Let
president,
may I only hand over one page.
what?
Well, the interesting part is when I took charge, there was a DDO. The managing committee was not there. And when I left the school, the DDO remained. So well, DDO is there when there is no managing committee. So well, the school fund, the government fund, I could not able to well, disburse or utilize. At least is the order of the DI. How I can use the school fund?
DDO কি করে?
We are not.
DDO only disburse the
That
salary.
is
You
Only salary.
you are nobody. When the
DDO
managing
salary
committee is
only.
not there, DDO is appointed.
Chopeshwar Sardar, probably the then district inspector of school.
It's not the administrator.
Well, may I, originally fact is that, my lord,
Complete first.
the area is SC, ST, maximum 90% population are ST, SC. My lord, per SC, ST candidate gets 10,000 rupees from the government. In his tenure, he has, my lord, fraudulently, my lord, taken all this money from the students. And for that reason, my lord, the villagers move this PIL, my lord.
The present appeal has been referred
My lord, may I take back those papers or it
No,
let
let
it be
it
kept?
be there. After we sign the order, you take it.
Well,
But I am for the appellant, my lord. I am led by Mr. Subir Sandal, my lord.
You are appearing.
Matlab Mr. Sudeep Sarkar, Sudeep Sarkar, advocate for the school authority, was taking a short pass over my lord. One matter is
School authority nothing to say in this matter, my lord. Last occasion, my lord was please
Yes.
direct me to settle the issue if any. Because, my lord, I got instruction from the DI that unless the Board of Primary Education, Board of Education is a give consent, they will not do. That's can you see? And board is here, my lord. Say Koeli Bhattacharya is here. I do not know, he has not made a party. In earlier petition, they have made party.
Board is not a party here.
I requested Mr. Bari, kindly make party to that, so that matter can be
In
solved.
the read petition, she was not party, my lord.
Yeah,
That's why.
এটা করে নিচ্ছে তারা।
করে
এটা একটু বসিয়ে রেখেছি।
হ্যাঁ, ঠিক আছে। না, না। হচ্ছে দেখে চলে আসবে।
No, you have been recommended to the school board, to which school? To
উত্তর রাজীবনগর,
Uttar Rabindranagar.
উত্তর রবীন্দ্রনগর,
Where is the school authority?
মানে দমদম।
No, no, who
Matlab-
is appearing for
Matlab,
this?
that school is not party here.
Then how you will join the said school? Your contention was that I have not been granted release by the Baroda school, so I could not join.
Yes.
So is the present school of where you have been recommended,
Yes.
is that school ready and willing to allow you to
Yes,
join?
yes, yes, my lord.
Where we will find? Yes, yes, my lord.
My lord, that read application, my lord, was there, my lord. I have not preferred any appeal against that read petition.
Which read petition?
My lord, I filed a read application during the pendency of that. Kindly
Oh,
allow
they-
me,
they
kindly
have
allow
not-
me to the new school without the no objection. This read petition I filed, my lord, earlier.
No, no, where from? Because the post in which you are working has presently been declared
Yes,
vacant,
yes, yes,
which
yes.
will be filled up in
Yes,
usual
Build up.
course.
No, my notification also it's true.
No division. So your only option is now,
To join the new school.
because what we are, what
My lord,
we
there
are,
was an interim order to that effect, my lord, not to fill up that post till that, my lord, in the new school.
we don't know,
My lord.
we cannot pass any order without ascertaining the facts.
Yes.
What we intend to do is, we will first ascertain whether whether the school to which you have been recommended, whether that school has any objection to allow you to join in the concerned post or not. One, if you are allowed to join the post, in that case, your other writ petitions claiming area dues since 2016 from which you were in duress, you are not allowed to join the school. That is a subject matter to be considered.
My
The
lord.
single judge has set aside that recommendation on the ground that the initial representation was under section rule 41B, but it has been considered under 41C. 41C is distance, 41B is when in a criminal proceeding and
Yes, my lord.
everything. That is the
Victim of crime.
so the division bench has directed, on the basis of which the commission SLP has been dismissed. It confirms the order of the division bench. Now, division bench has said, in terms of the 2015 rules and any other rule in the process, that is the direction of the appeal. So we can appropriately modify the order, saying that you will join the said school, and as regards your salaries and dues,
That will be
That
decided.
for you to be remanded to the
My lord,
court below for
very well,
the
my lord,
purpose of
very,
this.
very well, my lord. Kindly then, my lord, allow me to add that school, my lord, and to serve a copy. my lord.
এখন কি করে allow? How we will allow? You did not come in your
Otherwise,
brain.
my lord, kindly then call for the record for that writ petition before the single bench.
Why
Or I-
should we call
No,
for?
no.
It was your duty to make them party. Why didn't you
Very
make
well,
them party in the
very
writ petition?
Very well, very well. Very well, kindly, my lord, that will support.
What very well? Why
That will-
should you? Why should we give you that liberty now?
I requested him.
2016 writ petition pending recommendation was issued. You do not.
My lord, till this judgment by the my lord, honorable single judge, there was an interim order to that effect. Do not fill up that post to any other person.
See, we are trying to sort out the issue.
Yes, my lord.
If we don't know what will be the school's case, school is never a party to this proceeding.
No, school was party in another writ petition.
In the present,
No, not present writ petition. In another writ petition before the single bench, there was an interim order also to that effect. Till the disposal, they shall not cancel my appointment letter.
so where is that interim? কোথায় annex করেছো?
My lord, that,
Petition and which writ petition that school was a party?
my lord, I am coming, my lord.
There were 4 writ petitions.
Yes, my lord. My lord, I am saying. In which writ petition?
Was just full of show.
Yes, my lord, WP 30719 of 2016, that last writ petition.
What was the prayer in that writ petition?
That prayer, kindly allow me to join without the no objection. Since the school was not giving no objection, they have already issued appointment letter. My lord, appointment letter, kindly see the appointment letter of that school, my lord.
We have seen.
That is at, my lord,
You filed a writ petition. So was it not your duty to tell the court that this issue, whether it was under 41C or whether it is under 41B, is a redundant issue? Because
Well,
the
that-
appeal court order has been confirmed by dismissal
but
of
it,
SLP.
it was told, but at the court, my lord, single judge procedure on the basis of, since you don't have no objection, you cannot proceed. My lord, no objection is mandatory from the school authority. On that basis, the court, my lord, dismiss the writ application.
Now,
only
where
on
is
the issue
that
of no
school
objection.
That school is represented by whom?
My lord, no,
Bohra?
never appeared. That
No, no,
school
that-
never appeared.
That's why somebody is appearing, my lord. They are presently, new managing committee has come
Yeah.
and there are no objections. There are no
They
objection.
have no objection to issue the.
To issue the, yes.
Eh?
That, yeah. Just now we have seen there.
No, he has taken,
Oh, acha, acha.
yes, instruction
An
to that.
advocate is here.
তাহলে Mr. Debray, we will only modify the judgment to that effect. We will tell the school to which has been recommended. He will recommendation on the basis of recommendation.
But subject
allow
to my
him
lord,
to
board,
join.
board is there, my lord. Lordship kindly
Where is
add
the
the
commission? Where is the commission?
board, West Bengal commission is there.
Commission is.
No, the board is required for.
Because 5 years already passed for
Board declared the post to be vacant.
Yes,
Board
Yes.
declared the post to be vacant.
yes.
vacant and notification also.
No, so that post at Bohra, he cannot go back and join there.
No.
But at the same time, when the division bench has said this, that please consider the division bench order, Mr. Debray, at page 67.
67, my lord.
Kindly come to page 70, last paragraph.
It's 70, last paragraph.
Having heard the learned advocates and considering the rules which are applicable in this regard, and also the rules which have been subsequently framed for regulating the transfer of a teacher,
Right.
we direct the commission to take necessary steps. Now, this direction was affirmed by the Supreme Court, SLP dismissed. And
Right.
what did the Supreme Court say? Supreme Court said in page 90,
101. No, no, my lord. It is on my lord 100, page 100.
Supreme Court has said we would further add that the direction of High Court to Commission to take approach shall mean petitioner shall take the decision in accordance with the rules in force.
Of the postponed sentence, take approach. Takes as decision in accordance with rules in force. Then Lordship can modify the order.
No, I don't know. We don't know
Yes.
whether any vacancies existing in
Vacancy
that
or
school.
at present there is going to any vacancy or
My
not.
lord, he has taken instruction from that school also. Through the DI, the vacancy is still existing.
That Mr. Debray has not said. How can the DI say that school you allow him to join? Can the DI say?
I cannot.
No, my lord, the vacancy of that school is still existing.
Now appointment letter is to be issued by the board.
Yes.
If he is directed to go and join the second school, board has to approve such.
Board is the appointing authority, but
Board will give the.
board is the appointing authority on the recommendation of the service commission. Board is the authority who issues appointment letter.
Board is the.
But
So-
when one thing I submit,
Huh.
what is submitting that the school is still vacant, vacancy is there, that GI can assert, and because my lord, whatever vacancy was there, all that sent for the second SLST appointment. So my lord,
No, there was an interim order.
Any order there?
Yes, there was an interim order not to fill up that post.
Show us that. Only bole
Then,
diya.
then,
then it's different.
So if the interim order is there,
then
then
no question of
the problem can be solved.
One more comment in this matter, I am not appealing in this particular matter, but in 2023.
Huh.
Where my lord, his period of absence is more than twice. Because his period of absence is more than 5 years of absence. And as per the legal lordship, if there is a continuous absence of 5 years,
Huh.
then it is termed as deemed resignation. So my lord, that application is pending before the
Honorable single bench,
honorable single bench.
challenging the malad order of the
It's
Yeah.
erstwhile managing
But,
committee. He is
No,
on.
that is. Pardon.
WPA 22282 of 2023.
No, Miss Bhattacharya, what we are trying to say is, it was entire dispute was as regards the commission recommendation. This was the entire dispute. Now the commission recommendation, if today if we allow him to join, that will be without prejudice to the rights and contentions of all the parties in all the pending writ petition, whether it is because he will not get that period of salary for that period. 2016 till today 25, he will not get break of service. But
Lordship,
you
we
are
are
saying
clarifying
that
that.
due to break of service, his employment will go.
Because this writ petition.
So we will keep that point open. If it goes, it goes.
Because in that petition,
I mean,
challenge.
You produce the interim order that was passed. That post was directed to be kept vacant.
malad post is lying vacant. Malad so
No,
far
no, not your post. The school in the
but in the school, I am appearing on behalf of the school authority. Malad, malad I have taken instruction.
Also take instruction commission that whether that vacancy has been forwarded to any SLST or not.
Malad, my instruction is this: the school authority says the vacancy still exists.
Which vacancy?
Malad, hard
So
post.
you are now managing committee. You are ready to give him release order.
Malad, I will.
Huh?
I will. Malad,
Then
this
what-
school authority is suffering so many
Then your
litigations.
writ petition goes. In the writ petition which you have filed that he has already been absent for 5 years.
Well,
There
that
is
petition
no-
filed by
No,
me.
no. That is filed by her. Malad, order is challenging the order of the DI. Malad,
DI passed
declaring
what
the
order?
post of Malad.
In the post as vacant, as
No, not that post. The representation made that you were in absent for 5 years, so that will constitute deemed resignation.
yes,
Yes, that order has
was
been challenged by her.
Challenged by me.
Then what happened to that writ
It's
petition?
pending.
Well, at that
Justice Rai Chakraborty's list. Malad.
Oh,
termination of the petitioner from their earlier school and declaring the post vacant. Why in lordship? Because 5 years continuous absence as per the league rules.
then Mr. Buddy, how can we give you release? If your termination itself has been cancelled, then question of appointment does not arise.
Well, this is deemed resignation.
I don't know.
as per the league rules.
Not, they have passed an order, the post is declared vacant and treating him as deemed resignation. That's all.
Wait. So
That order
you
is
have
under
challenged.
challenge. That order is
you
under
have
challenge.
challenged. So unless that order of deemed resignation is set aside, how can we direct you to join the other post?
On the,
Can we?
the difficulties is, the bench is not sitting
Are
since long.
Mr. Khanal on the last occasion,
Mr. Sannal also last time told me,
Submitted,
call for that, kindly decide that.
So how can we
petition.
decide? That has to be decided. Then now we can say that you go and join the post.
Your lordship can consider, that writ application also, because the bench is not sitting, last 2 months is not sitting, my lord.
Who means?
Justice Rai Chattopadhyay. It is assigned to Justice Rai Chattopadhyay.
He's sitting
It
division.
is assigned to her, my lord. Her ladyship, my lord.
So how can we help you? If deemed resignation has not been set aside by the court, then you are no longer in service. Otherwise, we were desirous of calling for notice to the new school whether your vacancy is filled up, and to the commission whether it has been. If there is an interim order question, doesn't
That writ application may be tagged with this.
How can we do so?
Your lordship can.
Petition, you make an appropriate prayer for sending that writ petition to us. আমরা কি করে শুনবো?
The issue can be solved.
You go and mention it to her ladyship.
Judgeship,
Go and mention before her ladyship.
her
If your
ladyship is
ladyship
not
is
treating
able
since last 2 months.
Mr. Badi, we want to solve the problem.
Yes, madam.
Release
তাই না?
দিতে বল তখন তো
Very well, madam. I
This
shall
way
try.
the matter will
I
go
shall
for
try.
10 more years.
I shall
What
try.
will happen?
I shall try, my lord. I shall try.
And for suppose today deemed resignation is set aside,
I shall try.
imagine the financial burden upon the state, 10 years salary. 2016 to 2026. Once we go and join that school and it will be appointed. Once appointed, deemed resignation will become inoperative.
infectious.
So the deemed resignation was right or wrong, or if it is contrary to an interim order passed by the court in another writ petition, then that order does not remain.
My lord, I shall
Unless
take.
you make a prayer to that effect, how can we take up the
My lord, I shall try. I shall try, my lord, for assignment before your lordship. My lord, I shall try, my lord. ওইখান থেকে মেনশন করে রিলিজ করি না
It can be solved.
That matter, my lord, I am appearing on behalf of the school authority, my lord. My lord, in the matter where my lord, the deemed resignation is under challenge, my lord. My lord, the school authority, my lord, I am not agreeable because the school authority will lose a forum, my lord.
বুদ্ধি বের করেছে, বসেছিল পাশে। যেটা বলছিলাম না সেটা
বললে হবে না, ঠিক আছে। ওটাই জোসেফ বলছেন যে তুমি
লস অফ ফোরাম। You may not agree, but you will have to agree to the disposal of the writ petition.
My lord, obviously, my lord, for
So
that,
if
my
you
lord.
do not try to, Mr. Roy, try to appreciate deemed resignation, if that is upheld,
Yes,
then
my
this appeal becomes
infractuous, my lord.
সেটাই তো বলছি।
Infractuous, my lord, because of this fact, my lord. For that reasons, my lord, the honorable single judge passed this order in this.
No. Court,
Malad-
a single judge did not have any idea. His lordship was not made known about this fact.
Deemed resignation.
Ah,
My lord, yes, my lord.
show us which portion of the order it has been said deemed resignation. It is only on the issue no objection. Without no objection, he cannot join.
My lord, total, my lord, 4 matters.
Total or subtotal, I don't know. You show us that your writ petition deemed resignation was there. Paragraph 50.
Paragraph
it has
50,
been-
paragraph 50.
District Inspector of Schools by memo of
Police,
20th September declared the post in Baroda vacant on account of resignation of the teacher.
Yes, my lord.
না, but এই রিট পিটিশনটা কথা বলে।
Writ petition, this resignation was challenged by you.
Yes.
So you agree to this that you will not claim salary from 2016 to 2025 joining.
Malad, for that, Malad, I have to take
You
instruction.
tell us that, then your deemed
Kindly take it
resignation.
at 2 p.m. Malad, then Malad, I shall take instruction from my client. Kindly take it at 2.
She will not be claiming salary for the entire period.
My lord,
Then Mr.
if
Roy-
he is resigned, my lord, deemed resignation for, my lord, absence of more than 5 years as per rule 11(1) of the slip rules. My lord, his service already, he has already terminated from service. He is no longer in service.
He will take the point of duress. There was a criminal proceeding. There was a criminal revision application.
My lord,
You have
honorable,
threatened the lady.
honorable
That is your
division,
stand.
my
Then
lord,
we will
honorable division
appropriately
bench
deal.
presided over by honorable Justice Dipankar Datta, my lord. He has, my lord, this is, my lord, 9th round of litigation, my lord.
Mhm.
My lord, my lord, moved the writ petition before the single judge, my lord, without.
So what is your problem? We are not asking you. You are the school. Your school now today says.
My lord,
that
in this matter, probably,
you
my
cannot
lord.
take contrary stand in one matter. You are for the school. He is also for the school. When he says that I will release him, what is your problem? And for that, so that your school does not suffer, we will record that for the entire period from 16 to 25, he will not claim any salary. Finish.
My lord, then, my lord, the matter challenging the deemed resignation.
That is why we told, because the financial burden will be upon DI.
Unless, my lord, the order of deemed resignation is
what
set
I
aside, my
need
lord.
to understand one thing.
Yes, my lord.
Today that writ petition, suppose it takes 10 years for disposal.
Yes.
Writ petition, suppose any against order, appeal will be taken. Appeal, then it will go to Supreme Court. So by the time, if it is ultimately held that he should be allowed to join, then who will have to face the greatest trouble? It is the DI. Because it will be government exchequer. Deemed resignation will automatically, decision will go. Once the school is said that you do not have to regularize that period, deemed resignation will automatically go. It will be fresh service from that. Check it out.
My lord,
Kindly take
You
it at,
should have told us. We took the trouble of going through your brief.
kindly take it at 2 p.m. I shall take instruction from my client, Malad.
That will not happen. What is the writ petition first you mentioned before the single?
Lordship of deemed resignation, madam, satisfied with lordship. She is no more in service at present.
since 2021, he is no more in service.
Service, unless that order is set aside.
Taken it up.
That read petition was, when this order was passed, that was your lord's, like his lordship's list was appeared in the
Analogously
list.
hard. That
No,
was
but
also
not
That
analog-
read
that
application
number
was
is not-
appearing in
that
the list.
excluded matter. But hard analogously, matlab subject to correction.
That was in the list. But subsequently, after change of determination, lordship fixed the matter for hearing. Thereafter, change of determination matter goes
Then
the
you
another-
should have taken
another
steps.
bench.
You should have taken steps. Was it not your duty to tell the court that there is another writ petition? You decide when you have taken up all the matters. What can we do now?
Matlab all the four matters was analogously heard by the Honorable Justice Hiranmay Bhattacharya. But at the time of passing of this order, the judge, Honorable Single Judge, has segregated the matter from these three matters. These three matters with regards to absence from duty as well as challenging the recommendation issued by the school service commission, and in another
Where
way
is that segregation order? ওই মনে মনে
order
সব বলে।
আছে।
Where is that segregation that it has to be heard separately?
orderটা বের করে আছে।
I am giving.
বড় যেটা read করছে সেটা
হ্যাঁ, একসঙ্গেই চারটে ম্যাটার ছিল, পাঁচটা ম্যাটার একসঙ্গেই ছিল। স্কুলের
there
একটা,
are 4 read petitions.
Only 4 have been dealt with, Mr.
there was total 5 matters.
Correct. But
Yes.
now from the order, it seems only 4 were.
Yes, my lord. Because that matter was filed in 2023 challenging the deemed resignation.
So that was, he should have said that he had that read petition also.
My lord, Honorable Single Judge passed this order and fixed the matter on another date. And on the next date, my lord, Honorable Single Judge has released the matter due to his personal difficulty. Release
No, not personal difficulty.
Release করলো না?
Said যে হ্যাঁ, said only it's separate issue.
Separate issue. আসেনি বলে দুটো।
No fruitful purpose will passing a direction upon chairman to decide the issue.
Assigned.
কেন no fruitful purpose? কেন deemed suspension is operating. আবার বলে দিল যে you will get liberty to. How can he?
চারটে ম্যাটার একসঙ্গে অর্ডারও ছিল দেখো।
What is that read petition challenging deemed suspension order?
এখানেই আছে তো।
না না
নম্বরটা বলো।
WPA?
এই তো এর মধ্যেই আছে।
হ্যাঁ 322
না না
ও আচ্ছা 222
82. 82.
2282
222. 82.
ও আচ্ছা
Okay.
of
22.
23
এটা অনেক যে আমরা করতে পারছি না
Well, report is kept in record. I file one report submitted by DI as
So
well.
let the report as placed, comma, be kept on record.
My development.
Yes, who is there?
Lord, for the appellant, my lord. This is a matter, my lord, relating to grant of high scale of pay. Lord, the petitioner was appointed as a, my lord, approved as a honors candidate. Lord, kindly see the approval.
Yeah, give us 2 minutes. Order challenge is 30th July 2013.
Yes.
So writ petition was on affidavits. Writ
No, my lord.
petition was not on affidavits.
Not on affidavit.
So file a short opposition.
This issue has already been decided by the Lord Judge.
Decided.
Issue is no longer required to be decided further. If the honors category subsequently improve his qualifications, then my lord, he is entitled to have the
Postgraduate skill.
and the honors category approval honors. It has
You were appointed through School Service Commission.
no prior to that. Prior to that. Your Lord
Then
Judge,
what is your ground, Mr. Dhol?
My lord, at that,
I believe at present there is no ground.
no, at
Let Mr. Dole manage place. Page 81 is the order of the trial.
my lord, he was appointed as an assistant teacher, my lord, through School Service Commission. My lord,
Approval to the process.
my lord, kindly see page 20, my lord, paragraph 3. He was appointed, my lord, on first RLST.
He was wrong. 1999, it is through School Service Commission. Kindly excuse me. 1999 through School Service Commission. As the honors category.
Just a minute.
Page 50 is the approval.
Let us read the order. Where is the order of the DI which
My lord,
rejected
that
your
is paragraph page 70,
70?
70, which was under challenge. My lord, elaborate order.
You are still in service, Mr. Buddy? 2012 writ petition.
স্পেশাল কেস তো ঠিক করে দিয়েছি তো কি আছে
তা আমি কি বলবো এটাকে ডিসমিস করে দিতে?
কথা বলবেন
What?
No, my lord.
You're not ready?
No,
Then?
not that. My lord, he's asking what.
He was asking why are you making submission when the issue has already been decided by three judges bench? Fully covered, entire discussion, fully covered,
Where is that judgment, Mr.?
without any judgment. Only the one copy I have, I heard
The Utpal man.
Yes.
That it has to, but Utpal, this is for School Service Commission appointee.
School Service Commission, I was appointed.
Huh.
I was sorry that I said that I was
No, when you are appointed through School Service Commission, it is
I had
automatic.
honors category.
If you have appointed on honors postgraduate category, then it is automatic. You will get the higher scale.
That's why I was suggesting what argument he will advance before the court.
So, Mr. Dhol, you check up that and make your argument. So far as I remember that had he applied in a honors PG group,
Yes.
then enhancement of qualification with the relevant subject, pertaining to the same group, there can be no bar. You have to give, there's a circular to that effect also.
That is there, my lord, kindly grants me, my lord, sometime, my lord. I will. My lord, let it be tomorrow, my lord. Taken up tomorrow, I will bring.
Check it up.
Yes. My lord.
If you see, if you find any difference in that, you tell us.
My
We are keeping it in the supplementary list.
My-
Combine this, it will be not.
No. Let it be, my lord.
Me, in course of hearing Mr. Dhol, learned advocate, appearing for the appellant, has prayed for an accommodation to na prothome lekho. In course of hearing Mr.
I did prepare a draft. Good job.
It was not on affidavit, my lord. At the motion stage, relying the Sitikona, my lord, it has been
Regularization.
Monindranath Sinha and Sitikona it has been this.
This is also decided, Mr. Bhatt.
No. Subsequently, my lord, Supreme Court has changed his view. Monindranath Sinha and Sitikona is no longer good law. It has been, in other matters, it has been considered and said that organizing teachers have the right to be appointed.
Which judgment, Mr. Body?
It has been clarified. And relying that judgment, our division bench,
Justice Kehar's judgment?
No. That is Provisional judgment.
Provisional has been clarified by the High Supreme. And another judgment of Justice Doctor in a division bench on 6 July 2018.
The judgment of three judges, my lord, the Udayomesh Lolit and Ravindra Bhatt and Premadigan.
Paper books filed.
Paper book filed. But according to my instructions, there is no such teacher in the school.
Everybody দাও
Paper book আছে নাকি?
স্কুলকে পার্টি করতে
everybody বলো
কি করে এফআইআর করে ডিরেকশন দিই
it was disposed of motion stage and
No, paper book has been filed.
paper book has been filed.
Affidavit.
No evidence. There was no evidence.
Trial court dismissed the decision
Relying on Moninath Sinha and Mala Sitikona Maiti. Your lordships kindly have a look to this subsequent judgment of Justice Tandon. Entire discussion was made. Moninath Sinha, Sitikona Maiti, Pravir Ghosh. Reported CHN দেখে নিতে হবে তুমি ছিলে তো আর কি তুমি জানো তো সব কতগুলো ছিল তুমি
Take it up and come, Mr. Take it up and come.
Kindly see these two documents.
You give a copy to Mr. Badi. You also check it up, then we will hear it.
Kindly see the just
We have not read this judgment, Mr.
Factual aspect, if he did, let him file an affidavit. He says he's not working. Let him file an affidavit.
According to the certificate issued by the headmaster of the school.
So, Mr. Mukherjee, why don't you bring a supplementary evidence?
Yes.
Paper book has already been filed.
ডকুমেন্টসটা তো স্কুলের
Or you give the document. So give a copy to Mr. Badi and give one copy to us. We will consider that.
Yes. No.
What are you saying? What are you are giving?
দাদা
Kindly see page 2.
নাই তো কপি তো নাই তোমাদের কাছে কপি কোথায়
আমারটা নেই
ওটা আমার কপি দিচ্ছি হ্যাঁ দিচ্ছি এটা নিন এটা নিন
attendance register
2025 দিচ্ছে সে সার্টিফিকেট
You should have prayed for an opposition to the stay.
Yes.
No,
What no?
when the
You appeared before the coordinate court.
কেউ অ্যাপিয়ার করেনি আমাদের
nobody appeared, court appointed me to appear in the statement.
আগে থেকে আমরা ছিলাম না
Appeal court by an order of 27 September, paper weeks were directed to be filed. See, this is the order.
No, I was not there on that.
You were not there.
Subsequently, I was appointed by the Honorable Court on 21st April 2025.
Application টাই তো disposed of.
Supplementary paper book file করতে but that is
অ্যাপিয়ার করে পরে কাগজ
এটা তুমি একটা এফিডেভিট দিয়ে বলো আমি তাহলে ক্লায়েন্টকে ডেকে বলি
this is the document of the school and the board. But most probably the vital document is the board has not been made party. Only secretary has been party.
For that, you have to take appropriate steps, no?
No, West Bengal Board of Education who has upgraded the institution. Board has not been made party. And recognition memo has not been annexed.
So, paper book direction has been given, paper book file. এখন, how can we allow you to extend the pleadings now? How can we allow you to extend the pleadings?
No, I'm not saying that. This is the instruction. Court has directed me to take instruction. I've taken instruction. This is the instruction. If Lord Candy direct me, so that I can file an affidavit. That's no difficult. And the school has to be made
স্কুল তো পার্টি আছে
ঠিক আছে অর্ডারটা দিতে বলুন কোর্টের রেজিস্ট্রি থেকে অর্ডার যাচ্ছে
The school is being sought.
documents school
Which school? School is not a party.
Yes, yes. School is a
party কিন্তু appear করছে না
Not appealing.
not appearing.
documents তো থাকে
Notice of appeal has been served upon me. I do not know.
Dispense with.
Notice of appeal under the aforesaid rules.
Are Baba
How can it be dispensed with?
যে documents গুলো আমরা সব স্কুলের document
The documents which have been supplied by the headmaster of the school.
সে affidavit-টা করি না আর সে বলছে
And the gentleman signed as the headmaster of the school, he can affirm the affidavit. We have got it from the headmaster of the school.
informal paperwork direction was given. Notice of appeal was directed to be served. Notice of appeal cost and everything.
Notice of appeal has not been.
Well, I can't say right now.
According to my information from the department.
Anyhow, my lord, further service required, I can serve a further notice, no problem. I can serve the school authority when my learned friend is, and whatever papers are like to be used, my lord, let him supply the document or by way of affidavit, whatever he likes.
ওইটা করি আমরা যে আইপি রোডে নোটিশ অফ অ্যাপিল আমরা ডিসপেন্স উইথ করি যখন নোটিশ অফ অ্যাপিল করতে বললো পেপার হচ্ছে
আর কদিন কোর্ট আছে ওয়ার্কিং ডে এক তারিখ আজকে তাহলে এই 4 দিন
Mr. Mukherjee, you file a short application under order 47 for annexing these documents, and I am directing Mr. Bari to serve upon this school. Take steps to that effect.
Very well.
And the board may also be sought because the original approval or recognition has been granted by the.
Not required, not required.
You bring the documents on record. If it is so required, it is a question of regularization. Then if required board is necessary, we will consider that issue.
স্কুলের document annex করে
You have served upon paperwork upon the school, Mr. Bari. I think it has not been served.
আর এই document-টা দিন affidavit করতে হবে আমাকে
You did not.
কিন্তু এই একটাই দুটোতে যাচ্ছে
Mr. Badi submits, Mr. Badi learned advocate appearing for the appellant submits that.
জমা দিয়েছি সেটাকে করতে জমা দিয়েছি instruction
Paper books have already been filed and the matter is ready for hearing. না না রিপোর্টটা দিয়ে দিয়েছি ওই ওটা ওনাকে দিয়ে দাও আর জাজমেন্টের কপিটাও দিয়ে
University. My lord, I am praying for not today, my lord.
My lord, I tell your lordships, this is the matter where my lord, the college authority's appearance is required. The court directed to serve a notice upon the college authority, but it was my lord, came back with an endorsement that is the office is closed. So I am serving further. This is the in respect of the respect of the my lord, the qualifications of the B.Ed, where I was admitted under the my lord, management quota. To show me that registration was denied. That was the subject matter of the challenge.
give a notice come back it will be in the combined list.
Yes.
Yes, next. Not today.
Monthly list of November, your lords skip it. I shall serve the notice.
Yes.
একই তো ওইটাই তো সেম তো
Same. Not today. Yes, next.
My lord, I read by Mr. Arvind Chakravarty, my lord, on behalf of the applicant, my lord.
What is the application? Application কি এখানে দাও
এইটা তো My lord,
ভক্তিপদ জানা opposition file.
my lord, we received this opposition 14th August. My lord, give me some time, my lord. We will file reply, my lord.
Not today করে রাখো next monthly list to file it in the mail.
Yes, my lord. Grateful, my lord. Wonderful.
My lord, in this matter, I am for the appellation.
Paper book filed.
Yes, my lord.
What is the matter about?
My lord, petitioner was appointed as Anganwadi worker, my lord. As she did not disclose her higher qualification, her selection was terminated. Selection of appointment was terminated. My lord, trial court, my lord, single bench, my lord, rejected the writ petition only on the ground that the petitioner did not mention the higher qualification in the application. But my lord, there is a special bench judgment on that point. Thereafter, my lord, two division bench judgment also that if there is a higher qualification, then there is no bar. Government subsequently notified that higher qualification is not bar for Anganwadi workers. Requisite qualification, madhyamik.
But you suppressed your
Not suppressed. I did not mention, not suppressed.
That is
And the special bench judgment, my lord, special bench judgment on that point, my lord, 2010, and division bench judgment also on that point. Two division bench judgments and special bench judgment.
Yes, who is your other side?
My lord, Mr. Boyso is for the other side. I served paper book also and notice also served to Mr. Boyso.
To Mr.
Boyso, Bhaskar Prasad Boyso.
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 This was selection of which year? This was selection of
Selection in the year, my lord, on
দেখি পেপার বুকটা দাও
2012. I served Mr. Bosto before mentioning the matter. Well, 2001 petitioner passed MP examination. 2000, yes, ma'am. Order against the appeal, Millard, page to start from 27.
Have you brought the judgments?
Yes, Millard. Millard, kindly see the judgment of the division bench. Thereafter, I am placing for special bench. এই দুটো।
অ্যাসাইনমেন্ট না, এটা গ্রুপ টুর মধ্যে পড়ছে।
Same issue, Millard.
এটা কি অ্যাসাইন নাকি এমনি লিস্ট এসছে?
আমি নোটিশ দিয়েছিলাম তো।
বাট এটা গ্রুপ টু না তো। May I submit, my lord, this matter relating to, my lord, group 5 or group 6 Anganwadi worker appointment of, therefore, my lord, it does not come under the group 2, my lord.
It is a group 5 matter.
No,
Group 5 or group 6?
Group 5, not group 6.
Why?
Check করো না read petitionটা কোন গ্রুপে ফাইল করেছে।
It is actually my transfer brief, Millard.
Pardon?
Whatever it
My
may be.
transfer brief.
Then Mr. Please take it up. If it is filed under group 5, then we don't have the determination.
Millard, group 6.
Group 6.
Group 6, if it is group 6, my lord, then if it is not
Don't have the determination.
jurisdiction, that is the, my lord, my lord.
You are sure, sir?
Yes, Millard, according to paper book, Millard.
Yes.
Paper book, first page,
Group 6.
second page,
Yes.
group 6.
Group 6, my lord.
Actually, it is my transfer brief. My transfer
Whatever
brief.
it may be.
Just I
was under impression that it was assigned before your lordships. It may be. This is not assigned matter. It is not assigned. Therefore, my lord, this, my lord, this jurisdiction is not permitting.
Yes, yes.
group 6.
Yes, yes.
Huh? No.
Appearing for the appellate. You're there. Paper book has been filed. Application file, Mr. Basu.
It's not that matter.
Board of
Oh,
Governors.
yes, yes,
He
supplementary.
ordered that.
Yes, supplementary affidavit that has been.
Check
We have
this
found
order.
The division, honorable division bench presided over by Justice Shomen Shen Millard on Millard July 7, 2025 had passed an order saying Millard that
Yes.
petitioner was
This
on
is an
probation.
affidavit.
Huh?
Supplementary affidavit.
Yes, yes, yes.
You have
This is-
filed?
I see- Yes, no.
So
I
you
see
are
from the-
filing now.
yes, yes. It is ready. And we have served.
Yes, tell us.
Now kindly come to page 50 of the paper book. The read petitioner, who is the private respondent number 1 herein, he was the superintendent of this particular institution. While he was in probation, my lord, authority proceeded against him. Fact-finding committee was there. And on the basis of the report of fact-finding committee, it was decided not to confirm his probation. And he was served with page 50. This
And
was,
this-
my lord,
Uh,
by the resolution of the Board of Governors.
yes.
My lord, there are fourfold of allegations. May I read it for my lord? It is noted that this has been quoted from the BOG resolution. It is noted that Mr. Devhal, the superintendent, has been charge sheeted in a police case, Malda PS case number so-and-so, dated 4th of August 2009, and charge sheet number so-and-so, which predates his joining at GKCIT. Mr. Haldar has been additionally charge sheeted in another police case, that is English Bazaar case number so-and-so, dated my lord 14th of July 2016. Since favorable PVR is necessary prerequisite for government, quasi-government employment, and in light of the fact that Mr. Devhaldar suppressed the information at the time of seeking initial employment, this is sufficient cause for his probationary service to be terminated. My lord, I must be candid with your lordship. This expression, that suppression, that doesn't suit. Because he was offered with offer of appointment. Pursuant to that, he had to file an attestation form and to join his job. Thereafter, he was served with appointment letter. That was our procedure. Now, my lord, in between the offer of appointment and appointment letter, at the time of joining, he submitted the attestation form. There he disclosed all these things. The first case that he disclosed. Now he was appointed.
Both the cases were not.
No, that's one. Second one is subsequent to the
Subsequent.
subsequent.
One which predated was.
The predated that he disclosed. That he disclosed at the time of joining. By way of attestation form, that is the first opportunity he had to disclose. That I must candid. But it's a fact that he had this criminal background. Now the next, in addition, it is also noted that pursuant to the last BOG meeting, a fact-finding committee was formed by the director GKCIT. From the committee report, it is noted that he was absent unauthorizedly. He has also been involved in doing a tender without proper authorization from competent authority. It is noted that the contract work order of value of rupees 2.73 crore was issued without taking approval of the finance committee or BOG. Thus, not only there was no proper authorization for entering into such high value financial commitment, but also that the proposed financial outgo was for a value of about 4 times the earlier financial outgo on similar activity. In the light of above unsatisfactory conduct, his involvement and in anti-institute activities which are detrimental to the interest of the institution, and also his non-seriousness towards the duty as
demonstrated by his unauthorized absence, BOG doesn't consider it appropriate to confirm his probation. Accordingly, my lord, his probation was denied and he was terminated. Now,
So there was no proceeding initiated.
no. But for unauthorized absence, he was asked to give reply, explanation that he submitted. Thereafter, all those communications, those are placed before the fact-finding committee. If your lordship stands to
Fact-finding committee, he appeared.
Hello?
He did not appear in
No,
the
no, no. No, there was no notice was served upon him. There were only the documents which was in communication in between the authority and the petitioner, those were placed before the fact-finding committee. And the fact-finding committee at page 87, they have given their report.
Yes. So what did the single judge say?
Kindly come to page 142.
This was heard by the earlier bench. Yes, where is that order?
142. Dated 3rd of September 2018.
Give us 2 minutes. He worked from 2013 to 2017.
Yes. Now, during that period, there was no committee for giving any probation because this institution that was formed in 2010 and this was under the mentorship of NIT Durgapur till 2017. In 2017, for the first time, we got our director, regular director appointed by the central government. Now, once the director came, the process for confirmation or probation of all the staff, existing staff, that was proceeded. Now, 2 persons they found not suitable. One is before your lordship, another is Nur Alam. Now, those 2, they have been terminated. They have been terminated.
What is the wrong with the order, Mr. Jahan?
But if your lordships allow me, the first thing, that police verification report. Police verification.
That he disclosed.
Now, this disclosure, today I am to some extent handicapped because some judgments are not with me. But the Satish Yadav's judgment, it says, the Supreme Court latest judgment, but even someone discloses his involvement in a criminal cases, that doesn't take away the power of the authority not to appoint him.
But you appointed.
Now, he was appointed prior to disclosure. The offer of appointment prior to disclosure. At the time of joining, he, my lord, submitted this thing.
So he must have, there was no necessity maybe for.
There was no necessity. There was no necessity, it's fact, at that time, because there was no such clauses.
Then how
Only
he
in the
can
case
be-
of attestation that was there. Now, what
can be blamed?
now, being an employer, my lord, if we found that some persons having criminal background, now applying the Satish Yadav principle, my lord, we have the right. That's my submission before lordship, not to continue. And most the thing that 2.73 crores irregularities, involvement in that particular irregularities, financial irregularities, and ultimately that entire process that was scrapped by the authority, not by us even. That was reported to the ministry will scrap the entire thing.
Did you initiate any criminal proceeding against him?
We after dismissal, we didn't.
No, that's.
No, I say there was no defalcation. I can't say defalcation. There was an attempt. There was an attempt. I must be candid before lordship. You, without having any authority, without having any authorization, you published in NIT. When there was a requirement of 30%, that was enlarged or
why did the coordinate bench ask for this affidavit?
Yes. On that day, there was a question before the court whether he would be entitled to join.
Oh, you are agreeable to allow him to
resume his duty. No, there is a question. Resume his duty, and there would be liberty to the authority to proceed against him. Or my learned senior friend's submission was no. Once I am allowed to resume my duty, I am entitled to get back my entire back wages. Now, the court was of the opinion, if we ultimately dismiss this appeal, that was the condition, then
only the question of back
yes,
wages will
then you show that you were never engaged in any other alternative job.
So he has shown.
Now, he has submitted an affidavit. He said, I didn't file any ITR return. Once he terminated, he said, no, he didn't file any ITR return. And that was the query. A man without even zero income.
No, that is if we dismiss the appeal.
Yes. That if we dismiss the appeal, then it will come.
Then you argue on merits of the matter. Well, you are not ready today.
Some judgment would be relevant. Otherwise, I would be. Satish Yadav judgment.
Question, Millard. Sorry, Millard. He said, Millard, specific term suitability. It does not match with the Millard, the order of termination. It is punitive. It requires Millard a disciplinary inquiry. And Article 311 protection, according to my humble understanding, Supreme Court, it applies to Millard, a person Millard who was on probation. Second, he said Millard suitability term is inappropriate misnomer.
No, that we understand.
Now,
but
Millard, second, there was no show cause. There was no formal accusation of charge, meaning there was no disciplinary proceeding. And charges, what he said, Millard, is very serious. First of all, he said that the first charge goes because there is no suppression. In his usual fairness, he has said. And Millard, the rest part, Millard, he said he is not armed with the Satish Jadhav judgment. Millard, with deepest respect, Millard, I said, whether Satish Jadhav judgment, Millard has nullified, Millard, the law laid down by the Supreme Court, Millard, in Dipti Prakash case, which says foundation and motive. Foundation is the allegation. Without charge sheet, without holding any inquiry, whether, Millard, today this question, by efflux of time, 2013, 2017, 2 years, Millard, the probation period, you did not allow me to confirm. 2017, your new director came. Is it the submission of my learned esteemed friend that between this 2013 to 2017, there was no existence of the employer? And I had been discharging my duties, Millard, without there being an employer.
Want to use any opposition to this?
Lord, I couldn't find any document, my lord. Only
How
he
can I
only
prove
he
that by
denied I
evidence?
didn't file any income tax return, which cannot be believed. A person who had been earlier.
He has said that he was not gainfully employed, nor was he doing any
Yes.
business, and therefore he has not filed the income tax.
Yes.
That's his case.
Yes. Now a person who had been filing the item and even a zero income, he can continue with. And we have no access to verify the veracity of this particular argument. We made an attempt. I must be clear before Lordship. We made an attempt. But there is no, we have no access. We have no access to verify it. Because only the income tax authority, they can verify whether he filed any ITR return or not.
Can you argue on that?
Well, I shall.
Both the issues you argue.
I shall, my lord.
Tomorrow,
kindly.
as regards backwages, law is now probably well settled. Not gainfully employed, gainfully employed.
No, Millard, if the termination is void ab initio, then Millard, it has some ramification, Millard.
But this termination
Millard,
was based on non-conformation of probation.
No, that is so
there is no scope for any disciplinary proceeding.
You cannot claim privilege of your own irresponsibility.
Wait, Mr. Basu. Pursuant to the earlier direction of this court,
না আমরা টাইম পাই না
এই দুটোই কিছু ফিক্স আছে? হ্যাঁ, আমরা 4 ঘন্টা সময় কিছু ফিক্স Yes, we were, after you left, we were shown a copy of the order.
Supreme Court order.
You have got a copy of
Your
that?
Lordship.
So can we are keeping it on this Thursday then?
Your Lordship, could it be on Monday or Tuesday at 2 p.m.?
No, we are keeping it on this Thursday.
Your Lordship, as the FRRO and Delhi police will file, they had filed the affidavit only on maintainability grounds. So they will file, if required, additional affidavit will serve advance copy to my learned friend before the date. If it, that's why I'm praying it could be Monday or Tuesday as per your Lordship convenience.
No, the direction was there to file affidavit, not clarifying certain points.
What did we pass?
Your Lordship had passed. We had taken a maintainability petition with regard to Delhi, pendency of the matter in Delhi.
Yes.
And as well as here.
No, that
that is only dealt in the affidavit. The how Delhi police reached to a conclusion that he is a Bangladeshi citizen, that has to be dealt by Delhi police in detail in its affidavit. So that has not been filed. We have advised them to immediately file it by.
So do you have the order which you passed on?
Last orders.
There are specific direction, my lord. 6 points are there to satisfy on that score, my lord, by filing their affidavit. I'm showing.
We filed আছে কি?
Affidavit file করেছিল on the point of maintainability.
The first order, your Lordship.
File
That is order dated, my lord, 11/7/2025.
My learned friend has gone through the entire affidavit. It's only dealing with maintainability, nothing else. So we would require, as Supreme Court's order is there.
Oh, the deduction which we issued on 11th, we wanted the Delhi administration to answer the queries.
Your
So
Lordship.
that has been done.
That has not been done on merits. It has been only done with regard to the maintainability of the petition.
Very good.
How Delhi police has the power to deal under Foreigners Act, that has to be in detail provided in the affidavit. There's a separate 2-3 notifications which empowers them and how to be done. Orissa affidavit deals with that, but Delhi police affidavit does not deal with that.
Last 20 তারিখের order.
But in this order itself, we have passed such direction.
Your Lordship, in the affidavit, it's mentioned that only on preliminary grounds of maintainability, this writ petition, this affidavit has been filed. So we are
That is by the Delhi administration.
both FRRO and Delhi. FRRO has even reduced it to a shorter point.
But one affidavit you have filed.
We have filed 2 affidavit, one by Delhi police, one by FRRO Kolkata, FRRO Delhi. In both,
That is on the point of maintainability.
both on points of maintainability only.
So as regards the other aspects of the matter, you will file a further.
Your Lordship, by consent of party, Your Lordship may record an order that by, if required, will file a affidavit. My matter may be kept on Tuesday at 2 p.m. 10th
We
is
have kept it on Wednesday.
Wednesday.
We were short this order and
Your Lordship, Your Lordship,
postponement has
Your
been
Lordship,
sought for. So we were keeping it on Monday at 2 p.m.
Your Lordship, Your Lordship.
এটাকে তাহলে তুমি Monday 2 p.m. এ রেখে দেবে. We are not, because the matter is not in the list, it is upon mentioning. So we will regularize that on that date, that upon
Mentioning, Your
consent
Lordship.
it has been fixed. So please inform the state who is the state. Mr. Dotto, that habeas corpus matter. That Delhi, he was that migrant worker. It was told to us that Supreme Court was insisting of a similar matter. So we kept it on 10th. But now Supreme Court has passed another order in that, saying that pendency of the same should not. So they mentioned it to us. They are for the union, but you are also a party.
Yes,
So we are preponing the date and keeping it on Monday at 2 p.m. This is just for your information.
Amir Khan or Budu Sheikh.
There are 2 matters.
2 matters.
Huh? দুটো matter? তাহলে দুটো
Amir
matter
Khan and Budu Sheikh.
very good, we will keep both.
Much obliged. Your Lordship, in both the matters, the annexures are not legible, which my learned friend has provided. I had requested him earlier as well to provide a legible copy.
You please
Because these are the
look
identity
into
card.
it, otherwise the matter will
বললাম
be.
my lord, কি করে রিকোয়েস্ট করলেন করেন তো
হ্যাঁ বলেছি
মুখে
Yes.
keep law. রাখেন
Has concluded. I am to reply 10-15 minutes, not more than that.
এইটা পেপার ছিল।
But the points raised was, number one was enlargement of the scope of reference.
Yes.
Willard, the learned single judge Willard referred to the West Bengal Industrial Dispute Rules. Willard, my submission was that Central Administrative Tribunal cannot apply the state rules. Mr. Banerjee has accepted that.
No, Mr. Dotto, he made an argument that page 64 of the stay application, that prayer.
Yeah, I'll come to that.
All right, yes.
So first is, so far as we have the enlargement of the scope of reference by applying the West Bengal rules, Mr. Banerjee has accepted. Therefore,
Yes.
this stands answered, this point. Now, what is the effect of this? The effect is where unfair labor practice issue goes. Or in other words, both the learned tribunal as well as the honorable single judge could not have adjudicated on the unfair labor practice issue. Therefore, we are left with absorption. But on the aspect of absorption, first, Willard, the learned tribunal holds in my favor, to which there is no challenge, even Willard by Mr. Banerjee. Well, if your lordships are having Willard MAT 815, please take page 89.
Yes.
Please take page 89, the 15th page of the award. কত নম্বর পাতা দেখো?
15 নম্বর পাতা
15th of the award.
yes page 15 para 23
Para
23 of the award. But it's at page 154 of MAT 816. But I'll read only the last 5 lines. The authorized representative of the management has failed to explain as to how these workers are continuing with their job if the contractual period has expired. However, there is nothing on record to show that the workmen concerned were appointed as against substantive vacancies. Hence, the ratio of Uma Devi is fully applicable in this case.
this is your contention, Mr. Dotto.
No, my lord, this is below the finding.
No, para 23 starts saying,
Yes.
relying on the constitutional judgment, the management has contended.
But may I read it, my lord? Relying on the above decision of the Constitution Bench of the Apex Court, the management of Kolkata Port Trust has contended that the appointment of the workmen under reference was of contractual nature which expired with the period of contract. Though the added union has denied that services
Yes.
of the workmen under reference were of contractual nature, but the union itself has filed appointment letters of some workmen, say Ashok Kumar, Shapun Kumar, etc., in which it has been specifically mentioned that the engagement was contractual for specific period mentioned in the letter. These letters were issued to the concerned workmen for a specific period in short-term vacancy, but it is not denied, rather admitted by the management that the 53 workmen under reference are still working with the Port Trust. The authorized representative of the management has failed to explain as to how these workmen were continuing with the job if the contractual period has expired. However, there is nothing on record to show that the workmen were appointed against substantive vacancy. But this is the tribunal's finding after Millard analyzing the submissions of both sides. But my respectful submission is, Millard, the reference proceeds on the basis that these persons were appointed against permanent vacancy. The tribunal comes to the finding that they were not appointed against substantive vacancies. There is no challenge to this finding of the tribunal at page para 23.
No, that is on the issue that why Uma Devi will not apply. Tribunal also says that since the 53 persons were continued, if you subject to what you are arguing,
Yes,
that Uma Devi was held to be not applicable since it was not the contention of the KPT also that they were appointed against substantive posts. So in a way, it has been turned around to come out of the regards of Uma Devi. That is what subject to what.
But Millard, simply because they were not appointed against permanent vacancy as found by the tribunal, therefore, Millard, the tribunal had to travel to the unfair labor practice. This, Millard, just Millard for recollection, please come back to page 140. এই 140 টা তোদের কত রে? First page of the award. First page of the award.
Yes, 140.
Well, 140 may not match, Millard. I think
No,
it matches. Yes.
But it is even the 816 টা দেখছো 815 বলি 815
First page. The reference which is quoted
whether the action of the management of Kolkata Port Trust in non-regularizing the services of 61 workmen as per list attached engaged on temporary basis on the permanent posts. As mentioned in each name is legal justifies, if not what relief. Therefore, reference was these people have been appointed on temporary basis against permanent post. Therefore, are they entitled to regularization? Well, that was the reference. The tribunal, my lord, at paragraph 23 returns this finding as I have placed before my lord.
Mr. Dotto, you have in the list designated the post pertaining to which they were taken.
It's all temporary post. There is nothing on record to demonstrate that I have appointed them against permanent
But
post.
their counterparts were done so, and
No,
your manager itself said.
What was done was subsequently when permanent vacancies arose, some of these people, my lord, have been permanently absorbed in the permanent posts.
Then why a different yardstick in respect of?
But I don't have posts. I need to have, my lord, as your lordships have held, unless there are posts and vacancies in that post, I cannot make permanent appointments in those posts.
No, where is that portion that you have, apart from 53, you had no other post? That was also not your stand. On the contrary, your superior officer has said that yes, that was pointed as to us.
Yes, but the superior officers, they wanted these people to be permanently absorbed. There is no dispute on that. But, my lord, a superior officer's desire cannot amount to, my lord, creating a right in favor of any person. But finally, my lord, it is the ministry who is to take a call.
Yes.
But, my lord, as your lordships know that this Industrial Disputes Act and, my lord, adjudication under the Industrial Dispute Act has to be confined to the reference. If it, yes. Therefore, I don't say that the tribunal could not have done so. The tribunal ought to have sent the matter back to the appropriate authority for modification of the reference.
That usually happens.
Yes.
Yes.
Now, my lord, what has fallen from the court is that Mr. Banerjee had argued that that his clients have also applied for a retrospective benefit of the award. That was a submission made relying upon paragraph 22 of the writ petition. Now, please have a look at paragraph 22 of the writ petition. I mean, Mr. Banerjee's writ petition in MAT 815. It is page 57.
Paragraph?
Lord, Mr. Banerjee referred to para 22 of his writ petition.
Yes.
That the learned tribunal erred in law in directing the management of the port trust to absorb the workmen with effect from the date of passing of the award. Yes, sir. এই পাতার নাম্বারটা বল না হ্যাঁ ও Eight 816 তো রিটটা my lord, the other writ is only in 815. MAT 815.
We are in 815.
Right. 815, page 57.
Yes.
Mr. Banerjee Miller drew your lordship's attention to para 22, which reads like this, that the learned tribunal erred in law in directing the management of the port trust to absorb the workmen with effect from the date of passing of the award instead of the date of completion of 6 months from the date of their initial appointment. This, according to Mr. Banerjee, was a case made out for a retrospective benefit of the award. Now kindly take where the prayers at page 64.
Yes.
Where the first prayer is to implement the award by giving effect of the award from the date after expiry of 6 months from the date of initial appointment. Then prayer B, II, to implement the award retrospectively from the date of expiry of 6 months, so and so. Where this is not a challenge thrown to the award. Asking for implementation from a back date. But whatever it may be, now kindly look into what was the submissions made in court.
We are giving effect of the award.
সে দেখিয়ে দিচ্ছি দেখিয়ে দিচ্ছি Please take me to the 9th page of the judgment under appeal. Where Millard, the learned single judge Millard, records the submission of Mr. Banerjee. Page 9, para 28.
Yes.
Mr. Banerjee, learned senior advocate for the workmen, placed the provisions of Rule 20D of the West Bengal Tribunal Rules and Employment Exchange Act. He placed several parts of the evidence adduced by the parties before the tribunal. He argued that the tribunal committed an error on the first part of the reference, finding that the workmen were not entitled to permanent absorption. Then Mr. Banerjee relied upon so-and-so judgment. This is para 29. Then para 30. Mr. Banerjee further relied upon section 4.2 and 4 of the Employment Exchange Act, which specifies that Port Trust is required to furnish the number of permanent vacancies to be filled up. It is essentially in this context that 52 persons were sponsored by the Employment Exchange concerned. The engagement of only 35 persons in permanent post and that of the rest of the 17 as temporary contractual is expressly arbitrary, discriminatory and illegal. This is the sum and substance of the submissions.
Yes.
Therefore, my lord, in course of submission, there was no contention raised that the tribunal's award to this extent is bad and the tribunal ought to have given a retrospective benefit from 6 months from their appointment.
No, I'm sorry. I considered that my lord, Mr. Justice Manta put me these questions. How do you what do you expect from the date of the 4 months of the date of the appointment, or just date of the reference? I say date of the reference, not that from that date. It's something new, my lord, it's new thing. This is the reply. And I argued, forget about 20D. Let us forget about that. Does it mean the entire judgment will be vitiated for that? No. I argued several other points. So now he's trying to bring a new case here.
No, he's exactly saying that to you. he's saying that Mr. Banerjee's argument was not so. But the court, the remaining which he didn't say is, that is your submission, that the court asked me. And on that ground I said.
Well,
So it does not have the support of the arguments or the pleadings on record pertaining to grant of retrospective effect to the tribunal, sir.
The court asked me, I supplied, I submitted. Well, there are
What Mr. Dotto means to say is that you were also not, it was also not your argument that don't give it us from that date, please give it us from that date. This
My lord,
was not argument.
if my lord asks me any questions, I am bound to answer. And that I have done. My lord says, Mr. Banerjee, what is your, tell me first. And there are two writ petition, my lord. My writ petition has not been properly happened. Our writ petition, first writ petition. Their petition is second. When we move these applications, then he moved their applications after a long time.
After long time means?
About 8 months. Kindly see their contact. When they found that, well, they will be in trouble. After 8 months of the passing of the order, if I'm not wrong, something correct, he moved the paper the appeal. And we actually immediately, we requested repeatedly, they just implement the order, award, as a judgment. So they must come with, on the last occasion, they must come with a clean hand, with a clean mind. In one hand, they have deprived us like anything. At the fag end of the life, what we are getting? Zero. Total mana fide, my lord, what they've done, everything wrong.
Yes.
About 3 years, 3 years. Can record it, my lord, 3 years.
3 years for what?
My lord, I'm giving the, we filed this application on March 21, 2021.
Wrong
Writ
petition.
Your writ petition.
Yes.
Yes.
And their petition is.
There was filed after 8 months.
No, 3 years. Their petition April 2024.
You filed it in March?
We filed in March. March 2021.
And we filed in April 21.
24.
Both are in 21.
24 is March 24.
No, no. Adi, numberটা দেখ।
This is their petition. Kindly see.
Kindly see the order.
আরে WB নাম্বারটা বলো না, খালি তো।
Mr. Banerjee, kindly see the order. It says both are 2021. The impugned order.
Yes.
Both are 2021.
PA number 2021.
Impugned order.
See at the top, the impugned order records the two writ petitions.
Our writ petition.
Both are of
The
2020.
impugned order records the two writ petitions. So you will find both are of 2021.
Then I am wrong.
Have a look.
Now, your writ petition you have not annexed?
Petition officially passed move হয়ে
Writ petition
দর্শক বলে দুটো একসঙ্গে শুরু করো পাঁচ যখন মুভ হলো
Then they are misprinting, my lord. That is their fault. It's not my fault. It is written over there April 2024.
that is appeal affirmation দেখাচ্ছে ওই the affirmation of the appeal
Yeah, my lord. So what
stay
that-
petition affirmation issue
এই তোমার জুনিয়র মিস
21 read petition is affirmation 21
Now, your writ petition was, what is, this writ petition was 10267.
It is my writ petition. 10267 is my writ petition.
2024 দেখেছি তো।
8919.
Mr. Sen should not say something which is not there. This affirmation date of the stay application.
Well, I am also responsible. I ought to have checked it out.
Check up. Now, it
Why not?
confuses us. Na? Your proceeding.
Anyway, my lord, fact remains, my lord, that their contract is really questionable. Right from the beginning.
Yes.
হয়ে গেছে তোমার ডিস্টার্ব করা বসো
It's not a question of disturbance, it's my pleasure. তুমি আজকে তো বলা only problem, my lord. Now I'll have to leave.
One is filing of a writ petition is unknown so far as Willard implementation of an award of the industrial tribunal is concerned. The remedy is under the statute itself. Writ petition is not the remedy. Therefore, who filed the writ petition first is, in my very respectful submission, immaterial. Number one. Number two is whatever is not recorded in the order and what had transpired in court in course of a honorable judge asking question and Mr. Banerjee replying, I don't think your lordship would need to take cognizance of that unless it is recorded in the order. Because at times your lordships record in the order that on a query from the court, this was the answer.
Is there any ground in the memo of appeal on that point?
No.
There is no.
You have shown us. You have shown us. Memo of appeal, you have taken a ground.
My lord, I'm just coming back.
Therefore, my lord, from the submissions as recorded by the honorable judge, from paragraphs 28 to 30, my respectful submission is that retrospective benefit of the award, my lord, was not pressed before the learned single judge. Of the award. But the other point which has been urged by Mr. Banerjee is that the employment exchange.
Mr. Dotto, tell us, when there is a prayer, so what will be your answer? Court is exercising whether equitable principles are being applied, that if we give the benefit, they were in, because court has went forward to say even those persons who have not joined should get the benefit. So this exercise of equity is impermissible in 227. Is that your contention?
Millard, number one is Millard, the court is dealing with an order passed by a
industrial tribunal,
a quasi-judicial authority. Millard, here Millard, the court is not exercising power in the public law remedy field in the context of which Millard, Mr. Banerjee had argued. Because he has shown the case Jagannathan. The court is not considering the action of the state or union or the sovereign government.
Yes.
Where court is sitting in judicial review over a quasi-judicial decision.
Yes.
Therefore, the court will confine itself to the veracity, legality of the judgment. Court can uphold the judgment or the award. Court can interfere with it. Court can partially interfere with it.
But cannot extend the ambit of it.
In that case, Millard, the court has to formulate that point. And in this situation, court cannot formulate a point also, because we have all to go back to the reference. That what was sent before the tribunal for adjudication.
Yes.
And the retrospectivity issue, your lordship will not find any, with respect, Miller, no discussion in the judgment. Assuming for argument's sake that yes, Mr. Banerjee was asked, Mr. Banerjee had given some answer, and the court felt that it should be given, but there has to be at least a sentence on the retrospectivity. That yes, the court feels, but these are alternative. This is not a submission, my lord, which I want to advance.
Mr. Dattu, that line in the judgment which says the writ petition is allowed.
Yes.
Prayer A in the writ petition is a retrospective
Right.
implementation.
Right.
So if a simple one line it's allowed, why would it not mean that prayer A is allowed in its entirety and therefore retrospectively?
Will your lordships have, my lord, analyzed parts of a judgment? And your lordship have also, my lord, analyzed and distinguished between a judgment and a decree. In a judgment, your lordships first go through the facts, record the facts, submissions of the parties, conclusions of the analysis of the court, then conclusions of the court, and final is the relief, granted or not granted. We are at the middle of the final part. Therefore, the final part is to be preceded by a prelude of analysis. We're subject to correction, my lord. There is no discussion made on why a retrospective benefit should be given.
They have asked for that.
But at least I have not found that Mr. Banerjee had made a submission that no, why from the date of the award, why not from the date of their 6 months from their joining. But I would not waste your lordship's time. I'm sorry.
Retrospective.
Anything else, Mr. Dutta?
Therefore, my lord, to cut it short, once, my lord, Mr. Banerjee accepts that the tribunal rules West Bengal tribunal rules does not apply with the second part of the award rules, the unfair labor practice.
So why do you suppose if the rule is not applicable?
Then,
In that case also, you say that the regularization unfair labor practice aspect will go.
Yes, because there was no reference. Nobody was agitating before the tribunal, or may I put it in this way? My lord, this industrial tribunal adjudication has various tiers. The first tier is, I am an employee or a workman. I have certain grievance against my employer. Employer is not giving any credence to my demands. What I do, I first go and apply before the adjudicating authority, that is the conciliation officer. Before the conciliation officer, the employer is called. Either he attends or does not attend. There may be a settlement. There may not be a settlement. If there is no settlement, then the Assistant Labor Commissioner makes a reference under Section 10. Now, this reference is very important. This reference is based on what I am claiming from my employer, which he has not given. Where when the reference does not have an unfair labor practice aspect, it presupposes that I was not claiming or agitating a point of unfair labor practice, that is 1 day gap between the two tenure or periods of engagement. This is one aspect of the matter. The other aspect of the matter is that is enlarging the scope a complete bar, if this question is put. But my answer is, it is not a bar if there is a rule operative in the field. Millard, the state government felt that no, it should not be confined to the reference only. Therefore, the state government pillar formulated Rule 20D. But Millard, there is no corresponding rules in the central government. Well, please take me the reference at page 82 of MET 816.
Yes.
MET 816, page 82.
Not a state government.
So and so, whereas the central government is of the opinion that an industrial dispute exists between the employers and their workmen.
Where you are reading?
We're page 82 of MET 816.
816.
Tell us the internal page of the award.
But it's I'm placing from the order of reference.
Yes.
Yes.
That is quoted in the first.
Yes. But what is important is what is the dispute? Apropos my lord's query, whereas the central government is of the opinion that an industrial dispute exists between the employers in relation to so and so and their workmen in respect of the matter specified in the schedule. The industrial dispute is the matter specified in the schedule. Now, what is the schedule? Whether the action of the management of so and so in not regularizing so and so engaged on temporary basis on the permanent post as mentioned in so and so is legal. If not, to what relief they are entitled.
Under the state government.
Now, this is done by the central government.
Not by the state government.
Therefore, the dispute is non-regularization.
এটা তো 116 তে আছে ওনার কাছে যেটা আপশন
In MET 815, it is page 116.
All right.
So this was the dispute. Number 5 or 6 judgments Mr. Banerjee had placed. Number 1 is case Jagannathan 87. AIR 87, Supreme Court 537.
Yes.
Mr. Banerjee Millard had placed paragraphs 19 and 20.
Yes.
This is case Jagannathan's judgment below. Your lordships are aware that all judgments following case Jagannathan and preceding case Jagannathan say that where the government, where the state acts arbitrarily, the court's powers are unlimited. no dispute on that proposition. But we are dealing with a case where the court is sitting in judicial review over a quasi-judicial action. Principles of Jagannathan Made, in my very respectful submission, will not apply where the court is sitting in judicial review over a quasi-judicial adjudication.
Yes.
Kindly take me to para 20, just first 5-6 lines. There is thus no doubt that the high courts in India exercising their jurisdiction under Article 226 has the power to issue a writ of mandamus or a writ in the nature of mandamus, or to pass orders and give necessary directions where the government or a public authority has failed to exercise or has wrongly exercised the discretion conferred upon it by a statute or a rule or a policy decision of the government, or has exercised such discretion mala fide or on irrelevant consideration, or by ignoring relevant consideration and materials, or in such a manner as to frustrate the object of conferring such discretion or the policy for implementing which such discretion has been conferred, in all such cases so and so. So where the government is at fault, the power of the writ court is guided by the principles enunciated in Jagannathan before and after.
This will not apply in an industrial.
Yes.
Yes.
But the next judgment which has been cited is AIR 2008
Yes.
SC 690. But I don't know how this is relevant, because here the Supreme Court was considering whether a department of the government can be construed to be an industry. State of Rajasthan versus Ganeshi Lal. Where the point over here was whether the law department of the state of Rajasthan could be considered to be an industry.
No, he relied upon paragraph 13 and 14.
Yes, 13.
That is that you have to read it in its totality. You cannot say picking up a word in isolation, and moreover, there is always that portion was, there is always peril in treating the words of a speech or judgment as though they are words in a legislative enactment.
No, in other words, judgments cannot be read as statute. No dispute on that.
No, he's
But
argument.
am I at a wrong judgment? Because para 13 is a 2-line paragraph in AIR 2008 SC 690. Well,
This is State of Rajasthan versus Ganeshi Lal.
yes, I am also on that.
This is, we were given the AIR version. You are reading from SCC, I think.
But how does the paragraph start?
In Home Office versus Dorset Yacht. That's the first line. Paragraph 13. In Home Office versus Dorset Yacht Company. Lord Reed said.
Oh, I see. In Home Office.
Yes, yes.
It's an unnumbered paragraph over. It's part of para 12.
12.
In Home Office versus Dorset so and so, so and so, so and so.
Thank you.
Yes, yes. Well, no dispute on this proposition. But I do not know how this proposition would help my learned friend's client over here.
Yes.
The next judgment was, or the last three judgments are almost on identical points as to applicability of Uma Devi. 2015 6 SCC 321 para 17 has been relied.
সাইট করেনি কিন্তু বলেছি
You did not cite Mr. Banerjee, চলে গেছে? Mr. Banerjee left.
এইটা তোমরা সাইড করো নি 15/6 SCC 321.
three judgments they referred did not cite.
I see.
These are the three.
15/6 তো তুমি বলছো।
হ্যাঁ 15 6
15,
321.
21. আচ্ছা, copy দিয়েছো তুমি?
But if they have not cited, I don't.
They have
waste your
referred.
lordship's time.
They have referred with paragraph numbers.
Yes, but in all these matters, your lordships would find
Not cited.
Huh?
Not cited.
not cited. আচ্ছা তাহলে 15/6 321 not cited তো
15/5
15/5 786
not cited.
not cited 15/6 cited.
It is, sorry, I'm sorry.
Not cited.
It's not cited.
Cited.
Yes.
But you have not given copies.
Why, my lord,
Copies weren't given to us. You've cited, but copies weren't given to us.
how do I cite?
তাহলে সাইট হলো কি করে?
Copy দিলো না সাইট
No, no, primarily Harwood 2017 volume 9 SCC.
Say 17.
Oh, no, sorry. No, I have.
15/6, 15/5, 9/8. আগের দিন আগের 19/8/2010
I already tell you about it. নোট ছিল and
under
he
paragraph-
referred 15/6 he referred, and 2009 volume 8 is CC 556.
Right, para 34 and 36.
34 and 36.
Five.
Huh?
Paragraph 16
15/6
or 15/5, 15/6 or 15.
and 15/5.
And 15/5 786.
15/5. Yes, he referred to that.
Very good.
referred to and
But-
said that it denuded the power of the labor court.
Mhm.
Madhavi did not denude the power of the labor court.
No, all these three judgments say in a chorus that Uma Devi was not dealing with a case of unfair labor practice.
Right.
Now, having accepted that Rule 20D does not apply, I don't think, my lord, these judgments would have any application.
It's in 15/6, volume 6.
Yes. We have taken note, but on that day, Mr. Banerjee said that anyway, you give us. the other.
তিনটে দাও তাহলে 15/6 15/5 আর 9/8।
We have the other judgments.
15/5, 15/6, 2009/8 তিনটে।
9 and 10, then Canada Bank,
Yes,
para 36,
yes,
Delhi Cotton General Mills, para 20 and 21.
yes.
These are the 4 judgments you did. All right, learned book is appearing for the Yes.
Well, I am for the appellant. Today, my lord, none appeared. I am for the appellant writ petitioner.
Item number?
11.
What is the issue?
All the writ petitioners appellant are the employees of Bardhaman University. My lord, pursuant to the advertisement, they appointed after 2.5 years. University said, no, you are not temporary employee, not permanent employee.
So you wanted regularization?
Not regular, but pursuant to the advertisement, probation period 1 year. According to rules. After 1 year, my lord, they are silent, university. After 2.5 years, they say you are the temporary employee. For that reason, we have come before your lordship for that notification. The notification, they say you are the temporary employee.
What do we do, Mr. Chakravarti? You say a resolution adopted, nobody is here. So you don't, not today, Mr. Dekeda. You saw the resolution. Resolution was there.
Resolution was
You've seen it?
Nobody tells
Yes,
us.
ma'am.
Because we haven't got,
We have not been
nor were we informed by the bar.
My lord, practically resolution initiated by criminal bar for those two senior advocate, those two. For that reason, my lord,
At least somebody will tell us.
my lord, entered this building, my lord. No one communicated that code number 18.
So then maybe one party is not wanting that resolution. You come and tell us that also.
না না ও আচ্ছা ঠিক আছে এটা আমি
দেখবেন আচ্ছা তোমার দেখেছিলাম 365 দেখে দাও
হাতি কারেকশন তুমি সই করে দিচ্ছি হাতি কারেকশন